All right, welcome everyone. Thank you for joining us. This is a public meeting of the Judicial Nominating Board. My name is Eleanor Spotswood. I am the chair of the board. I believe we have all the board members here, either in the room live in person in Montpelier in the State House, or joining us virtually by Zoom. Again, I just said this offline, but to set the stage for our agenda this morning, we are here to consider some proposed amendments to our rules. This meeting is being held pursuant to Board Rule 14, which says that if we want to propose any changes to our rules, we have to approve it by vote in a public meeting. We might do that today. We might do that for some of these proposed changes and not others. We might just have a discussion of the public comments that we've received and talk about next steps. Any one of those options would be a great outcome. So a couple of other ground rules. Again, I reminded committee members of this before we went live, but because this is a public meeting, we will not be talking about any of the confidential information that we are used to discussing in our private meetings. Primarily, this consists of any information related to applicants that we've considered, especially including their identities. I think those are the ground rules. And I just a couple of other comments. I think as we get started, I think it's always been the goal of this group, and one of the pleasures of chairing this group, that we share a lot of the same really important goals that are important to me, goals that I know are important to all of you. And those, first and foremost, include consistently producing lists of as many well-qualified candidates and diverse candidates as we can. And I just want to keep that in mind as we are discussing, getting into the weeds on these proposed changes. That's always been our goal, and to do so with a process that is fair, transparent, effective, and hopefully efficient. But primarily fair, transparent, and effective. I also think, final thought, that we're at an interesting moment here when we have, I think more than half of our board members are terming out or retiring from the board. And I think it's especially important for us to actually have this conversation collectively, because there is so much collective experience in this room about how this board functions, and that's really valuable. So even if, at the end of the day, we're not ready to say, yes, this is a change we need to make to our rules, those of us who are continuing, or hopefully continuing with the board next term, will take the collective experience of this group with us, and hopefully continue the conversation as we go. So with that, I am going to, unless there are any comments from anyone else, seeing none, I'm going to turn it over to Legislative Counsel Eric Fitzpatrick, who is joining us virtually. And he's just going to walk us through the proposals that we're going to consider today. So Eric, take it away.
Great, will do. Thank you. And nice to see everybody. As the chair mentioned, my name is Eric Fitzpatrick. I'm the Legislative Counsel and attorney with the Office of the Legislative Counsel here at the State House in Montpelier. Our office also, by statute, provides some legal support to the Judicial Nominating Board, specifically with respect to drafting rules. So the assistance that we provide to the committee is not unending, but it's specifically tailored to drafting rules. And I think that's because of the confidential nature of the board's proceedings. And so that rather than have someone like me who's not a member of the board who would be there at all times, it's some specific assistance that the board may use at certain times. It's happened before, which other other times in the past when the board has needed some assistance with redrafting some rules, I've been able to help out with that, and I'm happy to be able to do so again. And I think if I heard the chair correctly, the specific changes that have been proposed that you're thinking about are, and I remember talking about at least one version of them at a meeting over the summer that the board had. And my understanding is right. You've looked at the language a couple of times so that it's not unfamiliar to everybody. But before I look at or talk to the board about the specific proposals here, I just wanted to pause for a second and see if anyone had any questions before we got started about the process or what we may be looking at. I also wanted to ask, I assume, and looking on the screen, it seems that everybody has a copy in front of you. Is that right?
Yes.
The folks that are in person have paper copies, and the folks that are over Zoom should have emailed copies as well. Yep.
Great.
Could you just clarify who is on this call?
Oh, absolutely, Tim. Thank you. And I forgot one of our members, Tim, is present only by phone, so can't see who's on the call. So virtually we have David Silver. I see your hand is up. I'll come back to you in a minute. Denise Casey and Senator Hooker, as well as Eric Fitzpatrick. In the room with me, I have the rest of the board members, Representative Gosselin, Representative Jessup, Senator White, Senator Collmore, Allison Stone, and Representative Richardson. And then we have a couple of public members here who perhaps we will hear from during the public comment period. So that's who is in the room. David, what's your question?
This is for Eric. In view of some of the comments made by the council to the governor, I'm hoping that when you address our proposed changes, you also address whether or not, in your opinion, these changes are consistent with our statutory authority. Yeah, do you understand my?
Yeah, I understand the question. I'm not certain that I would be able to give a full-fledged opinion in each case on every proposed change to the rule, but I'm happy to comment when I can.
Okay, thank you.
And I also did note that I have not seen any comments from anybody, so I'm kind of going in blind on that respect. I don't know what other concerns anybody else may have.
Well, maybe the chair can, when there is a particular rule change that that we're looking at that was objected to, or at least the opinion was expressed by the legal counsel for the governor that we were exceeding our our statutory authority, which I frankly don't agree with, but I would be interested in an impartial opinion on that. And maybe the chair can point that out to you at the appropriate time.
David, happy to pull Eric into some of those discussions. I would like to get him going, mindful of the time. I'd like to get him going on the walkthrough, and we can address some of those as we get into our board discussion, I think.
Yeah, agreed.
That was my question was, do you want Eric to do just a simple walkthrough and we only ask questions of clarification, and then we'll deal with all the issues together afterwards? Okay.
I think that's a good idea.
Okay, great.
Yeah.
Just wanted to make sure.
Yep. So questions of clarification for Eric as we go, and then we can get into the substance a little bit after that. I know Eric can't stay for the whole thing, but hopefully he'll stick around for a couple of questions after his walkthrough. That's okay, Eric. All right. Eric, go ahead, unless there are any other prefatory questions. Okay.
Great, thank you. So yeah, taking then a look at the specifics of the rule proposals themselves, you'll see that the first change is in Rule 5, referring to board members' conduct. And specifically, this is dealing with the issue of conflicts of interest, when board members may have a conflict of interest with respect to a candidate, someone who has applied for an open position in the judiciary. You'll see that, and I'm sure everybody knows this sort of standard approach, but the way new language is proposed in either legislation or in this case a rule, you see when you look at it, if language is struck through, if there's a line drawn through it, that means the proposal is to get rid of that language. And if language is underlined, then the proposal is that that new language would be added. So that's the way it works, as I say, in both bills and statutes. So if you look at Rule 5B1, for example, you have quite a bit of language that's struck through and quite a bit of language that's underlined. The struck through language, the idea is to, the proposal is to get rid of it and replace it with language that's underlined. So the existing rule generally, if you look at some of what's struck through, conflict of interest is defined in the existing rule. So that specifically lays out a definition of it as a personal or business relationship that the board member has with the candidate, and the relationship may influence or appear to influence the decision of the board member as to the candidate. So that's laid out expressly in the existing rule, a definition of conflict of interest. And if a board member has it, then the way the process that the rule sets up, if the board member knows of any conflict of interest that they have, then they have to report that to the chair, who then reports it to the full board, which then has the opportunity to vote on whether or not that board member should be recused or not. So that's the sort of existing process. This year, in 2022, the legislature adopted a state code of ethics. And that code of ethics specifically applies in the language of the ethics to all individuals appointed to serve on state boards and commissions. So, as you might think from hearing that language, and if you read it, and our office has reviewed that language and concluded that the Judicial Nominating Board is subject to that language. So that means that the JNB is covered by the state conflict of interest law that passed this year, at least in our view. The conflict of interest law, the code of ethics includes a very detailed conflict of interest provision. There's very specific express language on conflict of interest. It defines it. It outlines a process for what one does if one thinks that one has a conflict of interest. So I give you that as background because the idea here, when you look at the language, is to make those two things consistent. In other words, to incorporate the appropriate parts of the new state code of ethics law into the conflict of interest provisions that you have in your Judicial Nominating Board rules. So that's the idea. And you'll see that it specifically cross-references the state code of ethics in a couple of places, with the idea being that that's the way it's going to work, that you have this new state law that on its face applies to anyone who serves on state boards and commissions. So it makes sense to specifically reference and refer to that in your rules. So if you look again at the specific language, Rule 5B1, the proposal is to strike that definition of conflict of interest that you have in the rule now, and instead say, if a board member has, and it's changing it from knows of to has, if they have any conflict of interest or appearance of a conflict, as defined in 3 VSA 1203A, and that's the specific conflict of interest definition that's in the code of ethics that was just passed. So I can read that to you if you like. You can read that on your own, whatever you think is most time efficient. I'm fine either way, but I just want to kind of defer to you and the chair as to whether you want to hear it or not.
I don't personally need you to read the statute that's already passed to us. It doesn't look like anyone else does either. So thank you, Eric. Keep on going.
Yep. So that's what's going on there. A reference to the conflict of interest provisions that the legislature passed in 2022, which do apply to the JNB because it's a public board. The statute also, and I say the statute that just passed, also includes in it an outline of a process under which how a public board member proceeds if they think they have a conflict of interest. And that process is also incorporated in the rule in the new underlying language. If you continue down, in my copy, it's over onto the next page. I don't know if that's the same with your hard copy, but still in B1, if you continue on, the new underlying language says consistent with the requirements of 3 VSA 1203B, And that's this process of what a board member does if they know of a conflict of interest that they may have. It outlines what you do. You can either, the board member has the option. You can either recuse yourself, right? Say, I have a conflict, I recuse myself, or you can choose to proceed. The statute specifically provides for that as well. You have to provide a written statement if you decide to proceed, and you'll see that that language is here as well. Board member has to provide the board with a written statement that they're either going to recuse or not, and that's consistent with the statutory process as well. And then, and this is the one, and this kind of maybe goes to a little bit to what David Silver was saying as well. This is the one thing that I noted was an interesting question. And this is that next sentence, which says, upon request from any board member, the board shall vote on whether to affirm or overrule the board member's written statement subject to the requirements of the Code of Ethics. So sorry, I didn't notice this earlier, but I only just noticed this piece, that one sentence, and that may be fine. It's just an interesting question that because the statute, the new Code of Ethics statute, does not specifically provide for an overrule by the board of a written decision by the board member about whether to recuse yourself or not. So in other words, it provides for that first part of the process that they can say in writing, I'm going to recuse myself, or I'm not going to for A, B, or C reason. But there's nothing specifically laid out about whether the board can either affirm or overrule that. Now that doesn't mean you can't do it, because there is a sentence in the Code of Ethics statute that says the Code of Ethics established by this section does not prohibit agencies, departments, state government, et cetera, from adopting additional personnel policies regarding ethical conduct not covered by this Code of Ethics or provisions that exceed the requirements of this code. So it's an interesting question. One might view that as, well, it may not be specifically provided for in the Code of Ethics, but it exceeds it anyway. It's an additional requirement that isn't necessarily inconsistent. So I don't think that it's necessarily contrary to what the Code of Ethics provides for. It may well be viewed as perfectly permissible. It's just an interesting question that isn't 100% clear. So I just wanted to raise that and make sure that you all knew about it. And it only has to do with that one sentence and that one. Yeah.
Eric, clarifying question there. My understanding, and I don't have this language in front of me, but my understanding was that in the Code of Ethics, the state actor employee reports this conflict to their supervisor, and there was some kind of supervisory authority over the conflict statement. And that the intent of this was to give that supervisory authority essentially to the entire board rather than, for instance, to the chair or an individual. Is
Right.
that consistent with your understanding of the Code of Ethics?
Yeah, I think that process is consistent with that same idea. Exactly.
Okay. Thank you.
Yeah.
Eric, and just one other thing, isn't the written statement for when you're choosing to recuse yourself is also a little bit above, isn't that above what's required by the state Code of Ethics?
You mean providing a written statement?
Yeah. If you're choosing not to recuse, you definitely need the written statement, but do you also need it if you are
I think it was
recusing?
in the Code of Ethics, I believe.
I printed it out the other day at work, and I do believe it says, are you recusing yourself or not? I mean, you have some options there. You say what the conflict is, and then there's a square that says, I ask to be recused, or I ask to go forward. It's the same form. Yeah.
So if I could,
Yes.
thank you, Madam Chair. Eric, I just had a question about timing. This may seem like a small point, but normally in our process, we know ahead of time before we actually convene for the interviews, who will be interviewed. This just says the board member shall, in writing, prior to any candidate interviews or discussions, et cetera, I'm wondering whether if there came a time when no one did anything until the actual day of the interview and then said, oh yeah, by the way, it would seem to be just a little bit more awkward if whoever that was waited until then. So we might need to take a look at refining that so that we say prior to any convening of the board for interviews. In other words, I think it would make a lot more sense to have everybody understand that situation before we got together that day and then somebody put their hand up and said, oh, by the way, I should have told you. Because it would just delay things, it seems like. And maybe it's a small point, but I'll just throw it out there.
No, that's an interesting point. I think it's worth committee discussion later. I have some thoughts.
Before you share the applications with everyone. Yeah.
Yeah. Could also be something that the chair just addresses in terms of asking you all. I mean, the way we do it now is I ask you in advance.
You do, and that may be sufficient.
Yeah, but maybe it should be in our rules. All right. Points noted. Eric, what do we have next?
Next, I just want to make sure that the previous question was also answered. Was that, is that okay? We're all okay with the?
Yeah.
Ready to move on? Yep. Great.
Allison, are you satisfied with your answer to the previous question?
Yeah, I'm not sure. I remembered seeing something in the law that you didn't have to write it, but I was just kind of looking it up, but
No, I think you're right. I think you're right. That's why I wanted to follow up on that point. That if the way I read it, if you choose to proceed, in other words, you decide not to recuse yourself, that's when the written statement is required, at least by the statute. If you decide to recuse yourself, it does say, not that you couldn't do it in writing, but it just says you have to inform your supervisor. It doesn't necessarily say in writing in that particular case. But I think you're right. This is probably one of those cases where this exceeds the requirements of the statute. So it would perfectly be permissible to require it in writing both ways, if that's what the JMB wanted to do. I think that's consistent with the statute, certainly.
thank you.
Yeah.
Okay, so that concludes that subsection. There's also another piece that regards conflict of interest as well in subdivision 2, and this deals with the situation when an attorney board member has either an active case with a candidate who is as either an opposing counsel or a candidate who is a judge. So, for example, a judge may apply for a position on the Supreme Court, or an attorney in practice may apply for a position as a Superior Court judge, for example. And in either one of those cases, it's possible that a member of the JNB who is an attorney might have a case that's either pending before the trial judge or in which the attorney is opposing counsel. This proposal attempts to address that situation. And the way that it does that is it establishes a presumption of a conflict of interest in that case. So in other words, it's not a absolute resolution to the issue, but it's a presumption. So that the fact that a conflict exists in that situation, when there's opposing counsel who's applied for a job and there's someone on the board who's an opposing counsel to that applicant, or when the attorney member of the board has a case pending before an applicant who's a judge, there's a conflict of interest that is presumed. Now, that presumption can be overcome. It can be rebutted. You'll see in the second sentence of subdivision 2 by a majority vote of the board. So it's, even though the conflict is presumed, it doesn't mean that the board can't decide if a majority of the board takes this position that, well, it's a de minimis conflict. It's not something that rises to the level that we feel that the person needs to be recused, so they can vote to say that despite that, person can still participate. So in that way, the presumption would be rebutted but if majority of the board did not feel that way and did not vote to permit the person to continue despite the conflict, then the person would be recused and they could not participate anymore in the proceedings with respect to that candidate. That's the proposal here anyway, with subdivision 2. Is that understandable? Make sense to everybody how that works?
Yep.
Great. Okay, so moving on to subdivision 3 then, a different topic. This one very straightforward, very simple. A board member who doesn't attend a candidate's interview cannot vote on the candidate. Simple as that. Either if you're not there participating in the interview process, then you don't vote. All right, so that's moving on now to another topic. This goes on to Rule 10, which has to do with interviews of applicants, candidates. I'm sure everyone on the board is very familiar with the issue of the board having to interview every applicant who applies for a position, even if you've just interviewed the person recently with respect to another opening. The way the statute and the rule is read now is that every time a person applies, then the JNB has to conduct an interview of that person, regardless of whether you may have just interviewed the person recently when they applied for a different opening. So this attempts to address that situation, this proposal in Rule 10, by requiring that an applicant be interviewed only once during each 2-year legislative biennium. So that's the proposal. During that 2-year biennium, if more than one opening comes up, then this tries to create a process where if a person has already been interviewed for that opening within that 2-year period, then they don't necessarily have to be interviewed again. And the way that would work is it has to do with the determination of well qualified. So remember that the standard now for who the JNB submits to the governor is every applicant who is well qualified. The JNB determines that an applicant is well qualified, that person's name goes up. So the way this proposal works is that if that has happened within the previous 2-year biennium, if the JNB has already interviewed somebody, you've already determined that they're well qualified, you've already sent that person's name to the governor with respect to a position, an opening, and then the person applies again within that same 2-year biennium, then you don't have to interview them again. You can send that person's name to the governor. You can deem that person well qualified without an interview, because the logic that it's resting upon is that you already made that determination that they're well qualified within the previous 2 years, just relatively recently. On the other hand, if they're in that same 2-year window, the person applied for an opening and the board did not send their name up. In other words, they did not determine that they are well qualified and send the name up to the governor, then that person also does not qualify for an interview. Again, presumption being, but the board's already made that not well qualified determination relatively recently. So no need to conduct another interview. The decision that we made within the same legislative biennium still stands with respect to that person, and no need to do another interview. So that's the proposal for how that would work. Is that clear to everybody how that would work?
I see a question from Barbara.
So I just want to make sure that I understand in this language that we're sending the name along for the well-qualified candidate along with the updated professional, disciplinary, and criminal background information. So I'm wondering, because it's been a while since we looked at this, if something has changed for that applicant, they were well-qualified before, and they now have a disciplinary action or a criminal action that might call into consideration whether or not they're well qualified. The way the language is now, is that us passing that on to the governor to make that decision? Because we're saying, we interviewed this person, they were well qualified. Yes, they have a new disciplinary action that's getting attached and sent, and this group is not making a comment on that.
Yeah, that's how it's framed. Yeah.
There's some discussion here, I think.
Okay, I just want to make sure that I was hearing that. Okay, thank you.
That is the proposal, I think. Eric.
Yeah, that's the way I read it as well. Yep.
And the The other point to note, I guess, is that the candidate who has interviewed before successfully would still need to apply again. So they would be either sending their same application or, you know, an updated application of some kind to us. So they would be affirmatively asking for their name to be sent up again. We just wouldn't be doing the interview or further consideration. Is that right, Eric?
Yes, that's right.
Ella, may I ask a quick question on that? Would there be an opportunity, and maybe we should save this for discussion, but I'd feel better just flagging it now. Would there be an opportunity for us to indicate on that application that there is new information being provided, or that this is the same application being resubmitted, so that we don't get into a situation where we're assuming that it's the same application?
Yeah, that's a good question. I imagine that could be an easy fix, but yeah. All right, Eric, keep on rolling. I'm sorry I didn't quite allot enough time for you in our agenda, but this is very helpful from my perspective. It seems like board members are appreciating it as well. So thank you for walking us.
Good, yeah. I'm pretty flexible this afternoon scheduling wise, so we can help out as long as it works for you guys.
Great, thanks.
Yep. So that would move us next to Rule 11, I believe, which has to do with criteria for selection. And you'll see that right now, and I'm on subsection C of Rule 11, there are some, and this has to do with general criteria for the whole rule, I should say, has to do with criteria for persons to be appointed to positions of whether Supreme Court Justice, Superior Judge, et cetera. And there are some general criteria that apply to everybody, you know, whether that's, broad statements of our integrity, legal knowledge, et cetera, et cetera. But there's also a few specifics that apply based on the particular position that a person is applying for. So subsection C has a couple of those. You see the existing two sentences that are not underlined. For example, the first one has to do with Superior Court judges specifically. So for Superior Court judges, there's a specific requirement that the candidate have sufficient trial or other comparable experience that ensures knowledge of the rules of evidence and courtroom procedure. For the environmental division, there's an existing specific provision that the candidate be experienced in environmental and zoning law. So the proposal is to add something specific for Supreme Court positions, and that's the new underlined language. Similarly, a specific criteria for Supreme Court justice, which is that the candidate shall possess superior legal writing skills. So that's the proposal there. Moving on now to Rule 12, and this is, I believe, it's actually Rule 12 and 13, both the same thing going on. It has to do with the same issue, though, and that's the issue of the general standard of well qualified. Now, these are, remember, as I mentioned earlier, the way the statute is written, the Judicial Nominating Board must send up to the governor every applicant who it deems well qualified. Now, it used to be that it didn't say well qualified, it said qualified. And in 2016, the legislature changed the statute so that it was no longer just qualified, it was well qualified. And that the word well was added there to make that more specific. So one thing that's going on in Rule 12 and 13, you'll see, is that it's just making clear, just for the sake of consistency with the statute, in a number of different places, adding the term well qualified so that it's consistent with the statute that was passed in 2016. So you see in subsection A, making clear that the board, the names that get sent up are those who are interviewed by the board, and then they're selected and well qualified nominees are sent to the governor. That's what the statute provides, and it's just making that consistent. Does the same thing in Rule 13, specifically providing the names of well-qualified nominees are those that are sent to the governor. And then the last, sorry, someone said something there?
Tim, did you have a question?
I did, yes. Should we say on 12A, select all well-qualified, add the word all?
That's that's a fair suggestion, and would be happy to hear that motion when we get to the committee discussion. Thanks, Tim.
Yeah, I jotted that down too, just to remember it if it comes up in discussion. But the last piece, then, as I mentioned, the legislature adopted the well-qualified terminology in 2016, but there was no definition of the term well-qualified included in the statute. So the term itself is used, it's stated as a well-qualified nominees that have to go, but it's not defined. So the proposal here you'll see in subsection E of Rule 12 is to add a definition of well-qualified. And it comes from a report that the American Bar Association did. And it's basically verbatim from that report, no changes other than a couple of grammatical changes. But the language, as you see, it's laid out pretty clearly in front of you. It means that the nominee at the top of the legal profession, the nominee's legal community, possesses outstanding legal ability and breadth of experience, has the highest reputation for integrity, and demonstrates the capacity for sound judicial temperament. So I guess it expands or rather puts detail on the definition of well-qualified. The statute requires that that's the standard that the board use, and here the board provides some definition as to what that term means.
Did I see a question, Barbara?
Yes. So Eric, would you say, for those of us that deal with whether things are technical amendments or not, that the changes in Rule 12, whether or not we include the definition in there or not, but just making it consistent with going from qualified to well-qualified is a technical amendment rather than a policy amendment or a...
Do you mean, because there's two different things going on, do you mean just where you add the term well-qualified, or
Yes.
do you mean the definition?
Well, it would be good to hear your answer about, because I was at first just looking at going from qualified to well-qualified, if we would really call that like almost an oversight or just a technical amendment.
Yes, I would agree with that. If you're just talking about clarifying the term, yes, I think that, it wouldn't have been surprising or maybe if I had thought of it, I would have even brought it to the board's attention previously after the 2016 legislation to say, oh, you might want to make this consistent with the statute now that the statute says well qualified. So I think that's just truing up the rule with the statute. I think adding the definition is more substantive.
Thank you.
Yeah.
All right. Anything else that you haven't walked us through here, Eric? I think you've talked about 13. Any other questions? Go ahead.
No, I was just saying there's one little technical piece to Rule 13, just changing questionnaires to applications for accuracy, because that's what is sent to the governor. It's just a more accurate term. But other than that, no, that's I think I've covered everything.
Okay. Any other technical questions for Eric about the language or how this proposed language would work before we get into the substantive discussion? Okay.
Well, I don't know if I was thinking about like Rule 5, B2. I was just thinking about whether this is one where that would qualify as more of a requirement, or I guess you talked about it was the supervisor. I was just thinking about to the extent that we diverge from the code of ethics, the requirement that it needed to be more restrictive or some, I don't know, that was a language that I heard Eric say at one point. I don't know that this is maybe, you said it intended to be more like the supervisory provision in the code.
Are you talking about the
thing where we vote about the appearance of,
or the board vote?
the board vote?
I see. And And what, sorry, what was the?
I was just, so yeah, I was hesitating because I hadn't thought this through as much as I would have liked to before articulating, but I was just thinking about Eric had said something about to the extent we diverge, we can be more restrictive than the code of ethics, not necessarily less. And then I was thinking, does a vote to override an appearance of conflict, is that less restrictive? Or I hadn't really looked again at like to what extent it was, it lined up with what the point you made of like the supervisory oversight, and it's intended to sort of track that in a context where there's not a supervisor.
Right. So, question about, is this more or less restrictive than the code? And maybe we can give Eric a minute to think about that. And take it up in our discussion. Definitely flag that for discussion. One other piece, Eric, while you were talking, I pulled up the board rules just to get clear on our authority to make these rules. And I'm looking at Title 4, Section 601. D. It says the Judicial Nominating Board shall adopt rules which shall establish criteria and standards for the nomination of candidates. And then it goes on to detail the positions. Then I think the other place that the rules are mentioned is in the next section, 602. D10. Section 602D, I know this board has talked about quite a bit. It lists the attributes that a candidate shall possess. And then D10 is other. A candidate shall possess other attributes the board deems relevant as identified through its rules. So those are the two sections that I see to this initial point. But we can certainly, Eric, I don't know if you have anything to add to that or if I've identified those correctly. But
those are the two I had been aware of. I could certainly follow up and see if there's any others, but those are the two that I, earlier on at the very beginning of the meeting when the idea of, consistency with statutory authority was brought up. I'm aware of those two pieces, so those are the two I thought of as well.
Okay. So can I see your hand? Just want to, I'll get to you in 1 second. I just want to make sure we've covered the territory of everybody knows what we're considering, what this language currently looks like. And then after Ken's question and any others that come up, I would like to move to the public comment section of the meeting. So Ken, what have you got?
Thank you. So just going back, I think Allison started going where I'm going now. That word appearance in B1 under Rule 5, the word appearance, is that well defined of what everybody knows on that? So, I mean, that's a lawyer term or something that maybe I'm just not up to speed on.
That's the language from the Code of Ethics. So 1203A defines conflict of interest or appearance of conflict of interest.
Okay.
Sorry, I should have let Eric answer that. It's the perils of lawyers as chairs.
Does it define the
I don't think it's defined necessarily, but I'm not positive about that. I'll look at, but it certainly is used in the statute, and I would say that it is a commonly used term with respect to conflicts of interest. It's very, very common, so that it's something that I'm sure has been fleshed out over the years by courts and case law and that sort of thing. But yes, to respond to your question, it is a familiar term in the area of conflicts of interest to say a conflict or appearance of conflict. Now, does that mean it can be always specifically defined? This exactly is one and this one isn't? Probably not, but it is at least a familiar term.
Defined in the sense that the language I'm looking at says the appearance of a conflict shall be determined from the perspective of a reasonable individual with knowledge of the relevant facts.
I was gonna read that if you did, yeah.
Just, you know, about as specific as maybe it's gonna get, but anyway. Other sort of purely technical questions for Eric, or shall we move to the public comment section? Yeah, Barbara.
So given that we passed this new code of ethics, again, that takes effect no matter what we end up doing if the board chooses to approve this language or not, right? Like, so I guess I'm just wondering how that new law would get in these rules if the board were not to act.
I think it would apply. Even if you do nothing? Exactly. I think if you were to repeal this conflict of interest rule completely, that doesn't mean you don't get to have anyone can have any conflict that they want anymore. I mean, the statute would still apply to J and B members.
But Eric, to follow up on that, if we don't repeal it and we keep our current rules, we might be faced with some, maybe not conflicting requirements, but at least different standards in our current rules versus in the code, right?
Yes, I think, to the extent that what some of this is trying to do is to incorporate and reconcile your conflict of interest provisions with the pieces that have been newly passed in the statute. Yes, you're trying to avoid those kinds of, ambiguities, because the existing language, maybe not as clear if it's saying exactly the same thing as the statute does, and rather than, have that come up later on and people argue about which one applies and is it really more, does it exceed the requirements of the statute or not? I think you're trying to make it consistent so that those kind of disputes don't arise later on.
Any other questions for Eric?
Well, so
Yes, Cheryl.
Thank you. Eric, so regardless of what we do, the statute has the authority. I mean, that overrules whatever happens in our rules.
Yeah.
Unless what you do by rule is more the word, I'll go back to
More
the word again.
restrictive.
Yes, you do have that option to sue. Exceeding the requirements of the code of ethics is the language that it uses. So I think you do have that option. But if it doesn't exceed, if the requirements are less than the code of ethics, then yes, the code of ethics is what controls.
And so what we're doing by this proposal is to avoid any appearance of conflict, anything that would cause angst or unnecessary discussion, really, because the statute would have the authority or give the authority.
I think that's a big part of it, exactly. And there's a couple of places that have come up, that part about the board overruling that sort of thing, and the presumption that you could regard it as a bit more than the code of ethics requires. So, but other than that, yes, I think it's just trying to true them up, just trying to make it consistent.
Thanks.
Yep.
And it also moves some responsibilities that the chair has been undertaking to the full board. So it's not just one person that's responsible for
Especially if it is the chair.
dealing with these, conflicts that you have.
That's a good point.
Yeah.
Right.
Yes, that's right. Thank you.
Final questions? Barbara?
So I'm sorry, I had a note here that I just want to make sure that Eric you can sort of weigh in on answering. So back to Rule 5. Sub 3, a board member who does not attend a candidate's interview. So if I show up partway through a candidate's interview, I attended a candidate's interview?
You show up partway through a candidate's interview, I'm not letting you in.
Right. Okay. Okay, well, I just want to make sure that that is, and shall not vote upon the candidate, which is different than if somebody's recusing themselves and not participate in deliberations. In this case, again, a person might be able to participate in the deliberations if they're not recused, but did not participate.
That happened.
That's a fair point, and it may be, depending on what policy decision you make, that because if you look at above in subdivision 1, in that case, the terminology says if a board member is recused, the board member shall not vote upon the candidate and shall not participate, et cetera, et cetera. It may be wise to true that language up just so that someone couldn't argue. Well, it depends on what you want. If you want the answer to be, well, they can't vote, but they can participate, then leave it alone. But if you want it to be, they can't vote and they can't participate, just like it is for subdivision 1, you may want to say so.
So we're clear on what the proposal says. Okay. All right. So let's move to any in-person public comment. We've got 3 folks in the room. Would any of you like to join us and make a public comment? Terry, come on up to the table so that we can see you on Zoom.
Okay, I was just saying I don't intend to make any comments.
Okay. Thanks for joining us. Anyone else? Comments?
Hi, may I sit down?
Yes, please. Please sit down and identify yourself, and then feel free to comment. I would ask you to keep your we're running a little long, so I'd ask you to keep your comment to about 5 minutes if that's okay.
Sure, I'll watch the clock. Hi, I'm Jay Green. I'm the Racial Equity Policy and Research Analyst for the Office of Racial Equity. I use they, them pronouns, and I'm here representing my supervisor, Susanna Davis, the Executive Director of Racial Equity. Good to see some familiar faces on the board today, and hello to everyone who's participating via Zoom as well. I'm here to, I have no qualms or comments to make on the proposed rule changes related to the Board of Ethics changes, the ethics changes, or the, I'm definitely not commenting on whether or not the Judicial Nominating Board has the authority to make these rule changes. I specifically wanted to inform you all of the Office of Racial Equity's intention to introduce some provisions of a former legislative item called H401 of 2021 that was introduced. These are some recommendations that were made by the Vermont Racial Equity Task Force, which was a community member. And I think my supervisor said that she had already discussed this with the Judicial Nominating Board at one point. But there are certain parts of that H401 recommendations that are actually in opposition, I think, to, and EDRE Davis thinks, to the rule changes that are being proposed, specifically around the definition of what well-qualified means. The proposed reintroduction of H401 would actually remove the well from well-qualified because Executive Director of Racial Equity, Susanna Davis, is a bit concerned that that might unfairly privilege people who are already privileged by the current systems. And I think that, unfortunately, that's reflected in the composition of the judges that are sitting today, because no matter what the intent of our statements around not considering, for example, in Rule 5A, there's and I know that's not under consideration, but in Rule 5A, it says that the board shall not consider the race, color, religion, ancestry, et cetera, of a candidate. But we know from experience in other areas like affirmative action that when you apply race neutral policies, they tend to uphold the status quo and privilege the people who are already privileged. So one of the modifications that the H401 would add to the rules of the Judicial Nominating Board would be, and I'm just reading from what was already introduced in 2021, a candidate shall have broad range of lived experience and candidates shall be drawn from diverse backgrounds to represent the interests of ethnic communities and communities of color throughout the state. So rather than saying this is a race neutral policy, which tends to already privilege people who are in positions of relative privilege in our society, this would explicitly ask the board to consider diversity and consider the assets of having people with a broad range of lived experiences when they are applying to be judges, and consider what that kind of knowledge and diversity brings to the position of a judge. So the other changes that were in H401, which we are intending to propose the introduction of, modifying the number of members of the board from 11 to 9 and adding in the executive director of racial equity onto the board. I plan to ask her to, if we can say that executive director or a designee, since now she has me and my coworker, Shalini Suryanaraina, who's the education and outreach associate for our office. It's great for her to be able to designate other staff members to attend these kind of meetings in her place, because she's only one person. She can't be everywhere all at once. The other recommendations are encouraging data collection of the social demographic characteristics among practicing attorneys in Vermont to make sure that we are nominating candidates who reflect the diversity of the practicing attorneys in the state, and then changing that the number of years immediately preceding, sorry, let me back up, I'm tripping over my words. Changing it so that it's only 2 years of immediately preceding their application that a candidate needs to be practicing in Vermont instead of 5 years, just to open up the pool of candidates a little wider. And I don't, with all respect to the American Bar Association, I understand that you are working off of a definition of well-qualified that has been vetted by another organization, but I'm concerned that using their definition will basically replicate the systems that have already had the impact. It may not have the intent of creating an imbalance in the racial and ethnic composition of the judicial system, but it's had the impact of creating an imbalanced system where we see that most of our judges in the state are white men and not, there's still a gender imbalance. There's definitely a racial and ethnic imbalance with regards to the people who are judges in this state. So I'm concerned, and I think I'm speaking on behalf of Susan, my supervisor here, that using the American Bar Association's definition will have the same impact as holding the status quo. So I think that was 3 minutes. So I think that's all my comments. And I'm happy to answer any questions you might have. Yeah.
Thank you very much. Thank you for coming and for giving us those comments. I was not aware of that bill, but I will look it up. Yes, Jen.
I think it's the same bill we had last year.
Not the one that we all talked about.
Oh, it isn't. It had a lot of the same components in there.
Some of the same.
I guess my question, is it okay to ask
Sure.
a question? Thank you for coming, and we've seen you in committee a number of times, so thank you. I just am concerned about the reducing from well-qualified to qualified, and wonder if it might be possible to add a recommendation that, or a qualification that there be a broad range of lived experience, in addition to just having been a prosecutor in some place, or instead of reducing the qualifications. So it's just a comment, and I'm sure that the judiciary committees next year will tackle this one.
Yes. So I do want to make sure that we stay focused on the proposals in front of us and not the
Yeah, thank
legislation
you.
that may be introduced or will likely be introduced.
That's true. Thank you for that reminder.
Yep.
But I mostly wanted to mention that this policy will be reintroduced because I think it does somewhat contradict the definition of well-qualified, which, to me, it reads at like, how does one become, someone of good standing in the legal community? I think that it may involve a lot of, it's my understanding that it may involve a lot of networking and, the kind of opportunities that take place, in more informal settings, the kind of opportunities that are generally privileged to people who fit in with the majority, who fit in with mostly cisgender straight white men. And that has the effect of diminishing the capabilities of people who don't fall into those categories from participating in the system. If you limit it to the people who are really good at schmoozing, I mean, I don't mean to be I don't want to be flippant or informal, but I'm concerned that the definition creates sort of an incentive to advance more candidates who already fit in with the current status quo.
Thank you very much.
Thanks.
Right. I think we should move on. Does not look like Thanks for joining us. It does not look like we have other public comments in the room. So we're going to move on to a discussion. We have 40 minutes, and we have flagged a number of questions. So I think my proposal would be to start at the top at Rule 5 and have a discussion about any questions about the conflict of interest policy as written. Happy to have a general discussion, take motions to amend. Any of that. Looks like Eric is sticking around, which I really appreciate. Thank you, Eric. What are your thoughts on Rule 5?
Just a question. I know we got some written comments and there was the governor's comments to those. Maybe we can, hopefully everyone had a chance to read them, but just in terms of how we incorporate those, we'll talk through things that we notice as we go through each provision.
Yes, so we all of the board members at least have seen the public comments, both the ones I got by email, which I collected in a Google Doc, and the governor's letter, which came by PDF. Happy to put those on our website as well. If something jumps out to you that you saw in a public comment, feel free to bring it up. I wasn't planning to walk through the public comments systematically, the written ones anyway. But if you'd like to, something spoke to you, by all means, now's the time. Yes.
There was the first one that was in the document talked about the conflict of interest and if it should extend to someone who was a colleague as opposed to an opponent. And I just wondered if the attorneys could comment on that. I don't really have an opinion on it. It was there.
Yeah. So I'm just pulling up the comment. I think it was a comment about counsel for a co-defendant.
Right.
Yep.
In addition to opposing counsel, and whether we should add counsel for a co-defendant in there. David?
Yeah, I don't think that's necessary. And in fact, I don't think it's a good idea. What we put in here in Rule 5 as proposed is we created a presumption when you're adverse to someone, which I think is reasonable. If you have I've been involved in, I don't know, not hundreds, maybe hundreds of cases where I had co-counsel. just because they're co-counsel doesn't mean I even like them. And I may not even know them that well. It shouldn't create a presumption, you know, whereas the broad language, like if you have someone who's a part of your firm or a friend or someone who you routinely work with as co-counsel, that is probably enough for you to think, well, there may be an appearance of a conflict here. I'm going to address it and either say I should be recused or I shouldn't, but that's up to that's just a common sense interpretation of the ethical rules as they exist, which are necessarily broad, because if you try to come up with presumptions or rules for every situation, it never works out. I think that from my perspective, the presumption of a conflict is actually protection to attorney members on the board. I've been in that situation where, judges that I have cases in front of come up, and I don't know, should I get off? Is he going to be pissed if I get off? And should I stay on? Can I be fair? Or a prosecutor will have cases on. Well, they'd be upset if I get off, and I got all these cases. This protects us from that, and that's why I think it's necessary to have that presumption in that kind of case. I mean, that's from my own personal experience. There's other situations you could talk about, civil situations and others that would apply, but in my position, that's why the presumption makes sense. So I don't think we need to have something else about if you like somebody or you're co-counsel with somebody.
Thank you. That makes sense to me.
Okay.
That makes sense to me too. Yeah, I don't know. I was just trying to think. I thought it was an interesting point that the commenter made. I don't know. I definitely agree that where there's a case pending in front of the judge, that this is appropriate. And I was just trying to think about that. What would be different with opposing counsel? I think we talked about like negotiations and like this could be some sort of leverage in a negotiation. I think I'm comfortable with it as is. Yeah.
Yeah, I think these are the ones that we have in here are the ones that come up most frequently and are the most clearly troublesome. And I'm happy leaving the issue of counsel for co-defendant as you're still bound by the general ethical rules. And if you feel like there's an appearance of conflict, absolutely, you should still recuse yourself. But as David said, these are helpful.
Okay, thank you.
Yep. Any other thoughts on the proposed changes to Rule 5? Any motions? Oh, yes.
I'm sorry, Tim, just clarification on 5.3, a board member who does not attend a candidate's interview. It's minor, but should we say a board member who does not participate in a candidate's interview?
I don't know.
Don't ask any questions, but you're there.
Participate's a little bit more vague than attend, because you could be there and not say anything, and someone could say, "Well, you didn't ask a question, so you can't vote."
Right. Yeah.
I think
Am I participating in
Not
I did get caught in that once. I'm going to make a little trip here, but because my Wi-Fi went out with a certain candidate, and so I was only in about 2.5 minutes of the interview, and then I was gone, so I couldn't vote.
I do think this is the rule we've more or less been operating under, but in my mind anyway, it's helpful to make it explicit because we've had the conversation many times. Oh, I missed the interview for X reason, and I think what we usually come out is
Can't vote.
it seems unfair to the candidate. Yeah, Denise.
Just a clarifying question though, that we talked about a little earlier. Does that mean that you also cannot participate in the deliberations and discussion? And I'm not sure we've been consistent across the board in that regard. Should we essentially treat you as recused, or should we just allow you to be in the room but not vote? We should clarify that as well, just to be consistent.
Great comment. I saw Kimberly and then David.
Yeah, I'm just going into the land of what if for a moment, Denise, on that point. what if you happen to have been the individual who did the reference check? So there are just so many configurations of that Rubik's Cube. That's what just worries me. But I take your point.
No, agree. I'm not weighing in one way or another. I was really just raising it to say, like, can we just make, let's try to make a decision and try to be as consistent as possible. Yeah, good point.
If you're not recused, but you did the reference check and then you couldn't attend the interview. Gotcha. Yeah.
David, I see you.
I don't have a problem, and I treating a person who didn't attend the interview as just another reference person. I mean, if you're on the board and you have information, there's no reason you couldn't share it with the board. You just shouldn't be able to vote because you didn't hear that. So I don't think we need anything more than that. I mean, I think it's a good point that Denise brings up, but I don't think we need to be so specific. I mean, you could, because if you leave it out, then a person can participate in the discussions, or you could include, if the person the member who missed the interview has relevant information, they may share it with the board during deliberations. I mean, because certainly we get stuff from other lawyers or other people in the community, and we share it with the board. I don't see why we prevent someone on the board from sharing information if they know it. If they're not recused,
Right.
If they're recused, it's a different issue.
Yeah, so the recusal absolutely would be governed by subsection 1, and you would not deliberate or vote. That's in the end of subsection 1. If you're recused, you don't deliberate and you don't participate in the interview and you don't vote. Subsection 3, if you're not recused, but you missed the interview for some reason, as it's written, it just says shall not vote. So it doesn't say one way or the other whether you're going to participate in the deliberations. Presumably you've read the application because you're not recused. You may have done the reference check because you're not recused. So do we want to A, leave it as is, B, have a motion that says shall not vote upon the candidate, and make an amendment that says but may participate in deliberations? Shall we? What do folks think?
To make it clear.
Make it clear, says Jeanette.
If that's a motion to add the amendment, I'll second it. But may participate in.
For the sake of the record, which Cheryl is, I'm sure, taking copious notes on, do I have a motion to add any language to subsection 3 there? Sure. Okay. So I hear a motion from Senator White to add at the end of subsection 3 of Rule 5B3, but may participate in the deliberations, period. Is that right? Did I get that right? Okay. And I see it was seconded by David. And now, because we are in a hybrid format, we need to do a roll call for every vote that we take.
Is this just to add the language or just like to adopt this language?
This is to add the language to the proposal.
Okay.
And then we can, if there is a motion to adopt the proposed language, we can have that next or whatever that is. So motion to add the language, but may participate in the deliberations to that subsection. I will call your names in alphabetical order of last name. Denise Casey.
Yes.
Brian Collmore.
Yes.
Ken Goslin.
Yes.
Tim Hayward.
Yes.
Cheryl Hooker.
Yes.
Kimberly Jessup.
Yes.
Allison Milbury Stone.
Yes.
Barbara Rachelson.
Yes.
David Silver.
Yes.
Myself, yes. And Jeanette White.
Yes.
Okay, motion passes unanimously. we will add that language to this draft.
Should we have said yay instead of yes or no?
Nay.
Denise is
You're all a bunch of followers.
All right, but may participate in the deliberations added to this proposal. Do we have any other proposals to amend the language of Rule 5? Do we have any other motions to make?
I don't know. I'm just going to say, I don't really object to this. I think it makes sense. And I was just weighing, like, on the one hand, it seems like it's sort of fair that people that are voting all have the same, like, baseline, or at least in terms of, participating in the interview and hopefully reading the application. But it does limit us in flexibility if there's it also promotes participation in our meetings, but it limits us in flexibility in terms of Jeanette's situation where she lost the internet, or she knows the person has a lot of knowledge of them and their practice of the law, for example, and read the application and then lost internet, and as sometimes happens in Vermont, then that person doesn't get to vote, which could be the difference, in having enough people so I'm just throwing that out there.
Okay.
Yeah.
So on the other hand, it does open up what we heard described as a what if situation. If you do that, you're opening up the door to what if this, what if that, what if this, what if that kind of thing. I think much more inclined to just say, let a future board decide if they have, 5 people that for whatever reason can't vote because they couldn't attend the interview, they could change the rule. I think the way it's phrased now is pretty good.
Barbara?
So I think we also need to just assume, I'm not suggesting we change the language, but it's possible somebody could show up and not have read the application, but just participate in the interview and then vote. And that would be equally a disservice, or more so a disservice. And so I'm not suggesting that we put that language in. I think it's just a good reminder that we need to do our due diligence.
You have to pass a test on the application.
Ella can test us before he gives us multiple choice.
Right, no clip notes.
Yeah, I decline to do that. Okay.
Sounds like no one, unless anyone else has any, just throwing that out there and we can move on if no one else.
Yeah.
I move that we approve the Rule 5 as amended.
Second.
Sorry, the last thing is, I think Eric was going to come back on whether there's number 2 is more restrictive or not.
I don't care. I really care.
All right.
I can tell you that Brian and I, having dealt with this ethics code and Terry for months, this would pass muster.
Okay.
Also, what's the difference between having a supervisor approve or disapprove and having the board vote on it? There's no difference. In fact,
Does the supervisor approve?
Wouldn't you say that it would pass muster after all the
I would agree.
angst we went through?
Okay, so I'm hearing from our 2 most knowledgeable senators on this topic that this does in fact pass muster under the code. Allison, would you like to hear one more time from Eric whether he has anything to add? Eric, do you have anything to add about the board's approval or disapproval of board members' recusal statement?
I would view it as it does exceed the requirements so that it's consistent.
Thank you.
That's what that's.
Thank you.
Okay.
Thank you, Eric.
There we go.
Sure.
All right, so I have a motion from David, seconded by Brian, to approve the draft language of Rule 5 as amended. I am going to call the roll to approve draft language of Rule 5.
Many more copies.
I probably should have made more copies of this tally sheet. Great. Okay. Denise,
Yes.
Brian,
Aye.
Ken, Tim?
Yes,
All right, thank you, Tim. I heard a yes.
yes.
Cheryl?
Yes.
Kimberly?
Yes.
Allison?
Yes.
Barbara?
Yay.
David?
Yay.
Myself, I'm a yes, and Jeanette?
Yes.
Okay. Motion passes. We have approved the proposed amendment to Rule 5 unanimously. So moving on to the proposed changes to Rule 10. Who would like to start the conversation about the proposed changes to Rule 10?
I think
David?
Go ahead.
Jeanette, I'm seeing a volunteer in Jeanette.
So I will divide it into 3 sections. The first one is the biennium. And then the second one is the, if they're successful, and the third one is if they're unsuccessful. So in my mind, I do not know why we tie this to biennium. If we want to limit the number of interviews, we could say within the past year or the past 10 months. But if you look at this, if there's what do we call these things? If there's an application, we hear for applications in December of 2022, and then we have another meeting in February of 2023, that's 2 months, and people get to be interviewed again. But if we have one in February of 23 and another one in December of 24, they don't get to be interviewed again, and that's 23 months. So tying it to the legislative biennium makes no sense at all to me. If we wanted to limit the number, we could say if you're within the past year. And then I won't make comments on the other 2 here until a little later. But that's my comment on tying it to the biennium.
Okay. Other thoughts, Kimberly, and then I see Kimberly and then David.
The thought that's running through my mind as an argument for why it should be tied to the biennium is that the composition of the JMB moves as a body through the biennium versus the calendar date. So you could have a scenario where, I guess I would have to sit there and game it out, but you could have 3 different JMBs weighing in on a candidate, or the minimum 2. And I guess that kind of gets into where we're going with 2 and 3, which I appreciate your division. I would argue you get into that cumulative effect that I tried to flag earlier, whereas with one body, you at least have, I would say, some greater consistency in terms of the relative decision-making that is brought to bear on the other parts of this.
David?
I've been thinking about this, and I do think Jeanette makes a really good point. But I also think, I was thinking the same way as Kimberly, which is, I've been thinking about, is there a way to combine the 2? To say, because I do think, look, I've been doing this for 6 years, and I can tell you that in terms of our efficiency and the economical use of our time and resources, having to interview the same person over and over again, I think can be a waste of time, and it's a considerable amount of time. All of us are volunteers, and we're all very busy, and I don't think it's wrong for us to consider just like the judges consider judicial economy, I think we should consider judicial nominating board economy. I think that's important. On the other hand, I agree that there might be times where someone would apply in January of the first biennium, and that means they couldn't apply for over 2 years.
Right.
But so what I was thinking is, as I listened to Jeanette, something like you want to apply for within a year of your of your application, or a change in the biennium, whichever is the shortest period. Because that would be, because that way you have new people on the board, and they're allowed to use their discretion. They can come up to a different opinion, but on the other hand, you want to try to not have the same people over and over again on the same board. So if you're in the same board, they're going to have to wait at least a year. If it's not the same board, they can go right back. And I think that might be a nice compromise that addresses both concerns. I mean, it could be 10 months, it could be a year, whatever.
Other comments? Ken, is that hand?
But the same board, like what happens if somebody gets done? Then we've got to go through that process again. If one member is done like what I replaced, I believe I replaced.
We all did.
Well, no, if you say biennium, you're going to have a different board, right? I mean, you have probably different government. You might not have different governors or something. You have different legislatures, different lawyers.
Each of our terms is pegged to the biennium. So each one of us is either terming out at the end of the year or running for re-election and needs to get reappointed. So that's why the biennium is the sort of end date of the board's term.
Didn't know that.
Yeah. Yeah, Denise.
I'm not sure. I understand the desire to sort of peg it to when the board changes, but I actually think that the better approach is to consider that, we do need to give people a chance, their circumstance or experiences do change, and that there may be a circumstance that makes them, qualified when they were deemed not well qualified previously. And I think vice versa. Someone raised an issue of, judicial conduct or criminal conduct. And so I think the goal here is not to limit the number of candidates that we're able to send to the governor. It's to create some efficiencies and some consistency in an environment where we know that there's going to continue to be an increase, or at least we assume there'll continue to be an increase in retirements, so vacancies. So, from my perspective, tying it to a period of time, a 10-month window or a year feels better to me, probably just because it feels, I don't know, more like clean. A year feels better to me than tying it to the biennium. I guess I would just flag that I'm not sure that the changing of our composition is as important as our ability to say, is it possible that an individual or a candidate, there could be a circumstance that would make them well qualified when we otherwise deemed them not to be, or vice versa. And I think that's the more important thing.
Barbara.
So I had something similar going through my mind as that I was going to say that Denise raised. And I wondered about I like the hybrid idea that got proposed. And I wondered about either adding something that says, or if an applicant, either if the applicant not voluntarily, but requests an interview, or my other thought was that we add something that says, if a candidate is to appear before the same commission in the same biennium at least, that they would get, like it would be there would be a different set of questions that we would have that might be an abbreviated interview, but we wouldn't go through, it would sort of be recognizing that people change, but on the other hand, we don't have to go through the same questions that didn't change, like, why did you go into law or whatever that we might ask, and consolidate our process so that second time appearance folks get a different, more streamlined, but the opportunity to present to us.
I like that. I just started thinking about that a little bit today. Like I think I said, like a reconsideration, like in law when you're like a reconsideration, like there's some guardrails on it. So it's not just like, it's like consistent for each candidate that we're asking a more limited set of questions, like explain what has changed in your application since last time that you think we need to consider. And it's like
maybe a
shorter,
couple, right, like we have wiser questions that we learn from the, you know, or whatever, but yeah, but smaller, definitely.
So that's interesting. I'm wondering about what that says for the standards we're supposed to apply to repeat applicants. Because the process as is, we interview everybody. We have a clean slate every single vacancy, which is resulting in a lot of repeat work on both sides, right? We have repeat candidates that we consistently don't send up, and we have repeat candidates that we consistently send up until they get appointed, basically, or stop applying. And our current rules say interview everybody, send up everybody that's well qualified. If we were to take an approach that also said, and we're going to take the results of your most recent interview or round of application into account, I wonder if we would need to say something more about, presumption is that it will not change. We're not going to call all the same references again, but you tell us, I'm wondering how that would work. And how specific we would want to be in our rules.
I don't know that this is relevant right now, but I can tell you that I am thinking that I will vote against both 2 and 3. So just because I think that there is, I was just doing the math that you sent out on people who were, and I used 50 applications. And if there were 50 applications, that meant there were 12 repeats. And of those 12 repeats, 7 had no change. So we sent them up. That means five people had significant changes, but we won't interview them because we won't. And I don't think that's right. And then the people who had, were sending up, if they were well qualified and now they have some kind of a judicial disciplinary action against them, we're going to send them up anyway, but we're going to send so I am and still am prepared to vote against both 2 and 3, regardless of what we do with 1. Just so that, because I think that people deserve a second chance. They can improve or they can devolve.
Other thoughts on that? Are folks, if folks are happy with the process we have, that's a fine outcome too. Yeah, Kimberly.
Allison, just responding to you, you raised a point about the burden of showing substantive change falls on the applicant. And I'm just trying to think out loud, how would you know how much has changed if you didn't go through the same JMB?
Yeah, that's a fair point. Yeah. I don't know. I'm maybe struggling with some of the things that Jeanette is, but I appreciate, I think, I was also on the rules subcommittee, and I think that we do have it is frustrating to be interviewing, coming together, as David said, we're all volunteers, are coming together, seeing the same people and having a repeat process and not always having the, and more often than not having the same outcome. But I'm also thinking about, that smaller number of people, it feels like that are not getting on the list, that if we make a prohibition like this.
Can I go out on a limb as I start to hear the sawing? And it's that if you want to get a bit philosophical, you could argue the more you go through the JMB process, the better you get, presumably, right? So in some ways, you could argue that somebody who goes through multiple interviews is in fact advantaged versus disadvantaged. Different way of turning it.
Yeah, I think Judge Zone made the point in his comments that I think he was doing it in favor of having more, he wanted to have more names and people have the opportunity to go through it, but he was saying it can be an intimidating process and maybe it is an advantage, but it's also just kind of, maybe we're seeing somebody who's just a little bit more comfortable. I don't know that that's, better or worse view of them, but yeah.
I saw his comment, those comments kind of from like that, but in a little bit different light, that if you think you have one chance here, you're going to be so nervous, you're going to come before this board and this is your one chance in 2 years and you better perform. And I would be a nervous wreck. I don't interview very well anyway, but I would probably really blow it. And I just, at the very beginning, you pointed out 4 things that we're supposed to be: fair, transparent, effective, and efficient is the very last.
You said hopefully efficient. Yeah, I was.
I think that it is terrible to think that we're wasting our time and their time, but fair, transparent, and effective is more important to me than efficient. So that's just.
Denise.
Yeah,
I think you could say that for all legislators. They actually feel that way.
Oh.
I saw Denise's hand.
thanks. So I wonder, if we're sort of leaning against, and I'm not assuming everyone is moving this direction. I sort of am for the purpose of this statement, but understand that maybe we'll vote, maybe we won't. But, if we are to assume that we're moving away from this piece, are there other ways that the subcommittee discussed that we could consider that would help to make our process more efficient, that doesn't involve going through this process of automatically sending people up or automatically not for a set amount of time? So is there a streamlining of the application? Is there a streamlining of our interview process? I wasn't on the subcommittee, and I'm new-ish to the group. And so I feel like I don't have a lot of insight into what that might be beyond shorter application, shorter interview, or something like that. But I'm wondering if there are other things that you all talked about.
No.
Thanks, David.
But, can I respond a little bit?
Yeah, David, go ahead.
I don't know if I'm hearing objections to the policy that's iterated in this proposed amendment about sending people up that we've just interviewed and sent up without interviewing them again. Is there objection? Does anybody voice an objection to that?
I think there's just the one piece about what happens if they now have a criminal.
Right.
Yeah, that's.
That raises questions about integrity under that. Or whatever else.
Okay.
They punch somebody at a hockey game.
I kind of like Rachel's suggestion that as a compromise.
Or Barbara.
I'm sorry, Barbara. I always do that.
It's okay. It's turning out anyway.
Sometimes there are Rachels.
Can I just call you Rachel Barberson? That's what I'm like. I'm sorry, Barbara.
It's totally it's such a normal thing that people do.
I'm sorry.
Don't worry about it.
Representative Rachelson. Yeah.
Call me so David. Anyway, so Barbara's idea as a kind of a compromise or to address Jeanette's objection, instead of just saying, no, we're not going to, interview people again who we've rejected, interview them again, but we have a separate set of questions for people we've interviewed before. While it's not a clean slate, and yes, it's not as efficient, it is, I think, a reasonable response to having just interviewed them or interviewed them within a few months. Let's ask them different questions this time. Also, we don't want to address Kimberly's point. We don't want somebody who's just, I knew I'll do better at these questions. I'll practice them this time. I'd like to ask them different set of questions, such as, what has changed since the last time that you want us to address? What do you think we need to know that you didn't tell us the last time? or something like that. You know, we could come up with some questions. Well, actually, you guys are going to be the ones to have to come up with.
Didn't we do, David, I'm sorry, just a quick point of clarification. We have done that when there have been, and we change the questions every single time anyway, right?
Well, sort of. I mean, yes, we tried to, but there's a lot of similarity between them, I would think.
The same criteria we're asking about. Yeah.
So we haven't had a sort of distinct process or a distinct set of questions for repeat candidates. I suppose we could always consider doing that in a way that's consistent with our current rules, which require us to continue to interview every candidate. And I am conscious of the time. So not hearing a whole lot of consensus or appetite for moving this forward, I might suggest that we just let the next board weigh in on whether they want to change Rule 10 and move along in our last few minutes.
What if we just put like at least once? Is that bad, introducing like bad amount of discretion? So we're not like stuck with the one and
Do what?
at least if we just have subsection 1, eligible candidates shall be interviewed at least once within the past year or new biennium, whichever is shorter. Does that leave it too open for like discretion as to whether the board's gonna interview somebody or not?
I would let them decide the whole thing,
You would?
the board.
Okay, just don't touch it if we're not, okay.
It sounds like maybe we need a little more work on, I think there is a problem that we're all grappling with, right? If I could try to summarize what we're talking about here, because there's a reason that the subcommittee proposed this, which is that there is a fair amount of time and state resources, right? Like every time we meet, the state is paying for our facilities and our per diems and travel. So there is a considerable amount of state resources and our time and the applicants' time that's being spent on these repeat applications that generally don't result in a different outcome for the candidate, right? Like 70 to 80% of the time don't result in a different outcome, depending on how you count our recent statistics. So it also sounds like, if I'm reading the room correctly, folks are not ready to agree that this is the answer. So I would put it to the board that we take no action at this time. There will be a new board in January. And perhaps this requires a little bit more subcommittee work. Yeah, Brian.
Thank you, Madam Chair. So I hate to always use analogies, but I like them. And there's two people in the room that don't understand this. If you tried out for a hockey team and you didn't make it once, and you come back and try out again, it's the same process. You just do the same drills basically until you get better at them. So that's just sort of parenthetical.
You should add the hockey process. That's a great idea.
We already have it, right?
Yeah. But
Ask them to skate, Brian.
You can get better at hockey by practicing. Can you get better at being a judge?
I seconded one of your motions, David. I want that clearly remembered.
Okay, he has something more.
Yeah, I do think you're reading the room correctly. I don't think if we're going to have 2 o'clock as our ending time, there's any way we can get through Rule 10. We're probably not going to get through. We might be able to get through Rule 13. That one doesn't seem to be onerous, at least.
Maybe Rule 13 and Rule 12A.
Yeah,
Is,
possibly so. But anyway, I do think there's a middle ground here somewhere. I like Allison's, and actually it was David's suggestion, that the Rule 10A1, we could phrase it a little bit better so that we're not leaving out people over a 2-year period when we really want them to feel welcome and the ability to reapply. I think that's critical. I didn't know whether when we meet in December, whether we're going to have any time to take a look at this again, or whether we're just going to throw our hands up and say, we're done. Good luck to the next board.
So one thing we can decide at the end of this meeting is whether we want to hold another public meeting in December to take another look at this and maybe have, again, perhaps a subcommittee think about it over the period, because we are meeting again in December for interviews. Those will be closed meetings, obviously.
Right.
But we could tack onto that, assuming we reserve enough time in
Right.
our schedule, we could tack onto that an additional public meeting.
That would be my thought.
Yeah.
Can we have that public meeting at Head of the Woods at like 5:30 PM?
If you can work out the technology that might be required, no.
Do we know the date for our December?
That is the thing that we're.
Next item.
At the end of this meeting.
Sorry.
All right. So with time in mind, do I have any further motions without discussion on maybe 12A or 13?
I'll move that we adopt Rule 13 as proposed. I think that's just a technical one. I think the other one might take a little bit more discussion.
Oh, I see.
Motion to adopt Rule 13 as proposed. Do I have a second? I'll take a minute to look at Rule 13.
I'll second.
Sorry, I was just going back to look at it, to remind myself which one it is.
It just says well qualified instead of qualified too.
Application.
In applications instead of questions. Okay. I have a motion. I have a second. Is everyone clear on what we're looking at? Rule 13 as proposed. Okay. Motion to adopt Rule 13 as proposed. Denise?
Yes.
Ryan?
Yes.
Ken?
Yes.
Tim? Tim is on mute.
You're muted, Tim.
There you go.
Sorry. Yes.
Great. Cheryl?
Yes.
Kimberly?
Yes.
Allison?
Yes,
Barbara?
Yes.
David?
Yes.
just with the hyphen in between well and qualified.
Myself, yes, and Jeanette?
Allison wants a hyphen between well and qualified.
Oh my gosh.
Allison, I'm gonna come over there.
All right. Do we,
Well, may I ask a question first about Rule 10? Do we have to do anything? We just leave it alone. We don't have to.
We don't have to
say,
move.
okay, to not accept it. Okay, great. I just wondered.
no. Okay, so Rule 13 as proposed is adopted unanimously.
11, Ella, you skipped over that one.
Oh, I did skip over
Supreme
11.
Court, a candidate shall possess superior legal writing skills.
Oh, right.
Given that there are parameters around the other three, and the Supreme Court is kind of where the buck stops, and it's as everyone here knows, taking an action to potentially overturn previous judicial action seems really important to establishing precedent, and therefore I like the addition of writing skills, because part of the job is communicating both to the public and to colleagues about why. I think that's an important addition, and I would support it.
Are you making the motion?
I am. I make a motion that we approve 11, the final sentence, for the Supreme Court, a candidate shall possess superior legal writing skills.
I think Denise was going to comment.
Yeah,
Motion,
well, I just have a question, but I can wait for discussion.
well, we have a motion to pass Rule 11C as proposed, which is seconded. We can have a quick discussion, Denise.
Yeah, that was one that the governor's council had flagged. And I'm wondering if somebody can help me understand. The concern there was that the term of art, superior legal writing skills, is subjective. Is that correct? I just need a little help understanding that, if anybody is willing to help translate.
It's no.
Otherwise, I'm going to need a minute to go back to the letter and make sure I can understand before we vote.
You mean that very condescending and almost offensive
Okay,
letter?
David.
I found it to be constructive. I just want to understand.
I disagree.
I just want to understand the I just want to understand the concern to the extent that we're inserting language there. I remember that we've had a discussion about writing as a board, and I found that discussion to be really helpful as a non-attorney member of the board. So anyway, I would just appreciate understanding what the concern was there. And if no one is willing to help me translate, then I will just need a minute to go back and review the letter.
That's fine, Denise. Hold on, David. My understanding was that the concern was that it was subjective. But if anyone has a more nuanced take on it, I would be happy to. David, if you can keep it civil and
I'll keep it
relevant.
civil.
Yeah,
I don't
please
think
do.
the word superior is any more subjective than any other of the qualifiers that we have in the statute or in our rules. Well qualified is subjective.
Although we have a definition for that, right?
No, we don't.
No.
We're trying to provide
Another
one.
item.
We're trying to provide one in this amended rules. But well qualified is not defined by the statute or by the legislature. And that's one of the reasons why there's a proposed amendment in 12E. But what I understood the governor's council is saying is that they don't really need to be good writers. They've got clerks and stuff like that. And that's really what she said. And I don't see how, saying that it's subjective is like any other term that like highest level of integrity or a great someone who's, all of it's subjective, and so I don't think it just gives us some guidance that we want someone with excellent writing skills. Doesn't maybe excellent is better than superior, but what Kimberly said is absolutely true. Be able to communicate clearly to not only other lawyers and other judges, but to the public what your basis for your whole reasoning is, basis for your holding is so important. And even if you've got clerks, that doesn't mean they're good writers. You have to be a good writer to be able to edit them.
Right.
So all we're looking for is someone who's got excellent writing skills. And I don't think that's too much to ask for the highest position in the judiciary.
We apply that standard, excellent writing, superior writing. So we apply that in our own analyses of all the candidates as far as what I've observed.
So I see you, Jeanette, and I think, Jeanette, go ahead, and then I'll.
No, I just think I agree with Kimberly and David that if somebody can't write something so that I can understand it as a non-attorney, I'm a little less concerned about that for a superior judge, but for a Supreme Court justice, they ought to be able to write it so that I, as a non-attorney, know what they're talking about and can understand it. So and you're right, everything is somewhat subjective here. Everything, all these terms are somewhat appearance of conflict of interest. It's all somewhat subjective. So I support leaving it the way it is.
Ken?
So we're looking at a letter from the administration, and then I think we heard testimony in this room today that doesn't agree with that. And I don't think we have enough time to go over this, to do due diligence of what needs to be done on this, because it's clearly stated out in this letter what they're looking for. I happen to agree with that letter, and I think I believe I know what everybody or some sitting around this table and on the screen there are talking about, but it's also pretty well spelled out in this letter also what they're looking for, and what I also believe I heard in person today.
Do you agree, Ken, in the letter that the clerks and other unappointed behind the scenes, non-public officials should be picking up the writing slack? You agree with that?
Is that in the letter?
That is in
Yeah.
the letter.
Where? I don't see it.
It says here, candidates have, let's see, this is all in addition. There's
There's nothing in her explanation of Rule 11
Yeah, I see nothing.
that addresses that.
Here we
I thought
go.
I saw-
Final, second to the bottom of page 3, paragraph, final sentence. Moreover, there is a growing body of evidence that legal writing is not a good indicator of knowledge, talent, or temperament, which sort of begs the question, why issue opinions? Given the thorough editing process most legal writing will experience. I mean, here in this building, we have large counsel, we have help, but you have to have a certain fundamental, again, to me,
So we have a motion on the table. It is 2:02. I want to make sure that we're not about to lose anybody if we go past 2 o'clock. I know some folks had some later in the afternoon issues with
I
time.
can stay just for a few more minutes, but I can't stay for an
Okay.
extended period.
Yeah, I'm the same. I have a 2 o'clock. I told them I was going to be late, walking over, but I don't.
Okay, so
I just want to respond to Ken's comment about that we heard testimony today about this. We did not hear testimony about this. What we heard was that there's going to be a bill introduced that changes well qualified, but there was no comment made on the superior writing skills.
I will, oops, sorry, it's not for me to speak after.
yeah, please, you can respond very, very quickly because we're.
I did not make any comments about this for writing skills, but I do question whether superior writing skills is subjective in a way that privileges people who are already privileged with regards to their education level. But I mean, again, I do see that this was argument that they're ranking the Supreme Court justice that is necessary regardless of whether that privilege position is privileged or not. So I see both sides of this argument.
Okay, so I think we should probably take a vote at this point because we are out of time. We have the motion on the table. We have done a lot of discussion about the different demands on a Supreme Court justice, the different ways they spend their time as a justice versus as a Superior Court judge who tends to be on the bench a little bit more. And I think this proposal grew out of that. So I'm thinking we should vote at this point and
Can I make one more comment?
Yep.
I will be voting no, but it pains me a bit because I do believe that writing skills should be taken into consideration. I feel uneasy about things that do feel like would privilege some over others. And I feel like our process is well-rounded enough as it is that we do take into account writing capabilities in the sort of broader group of skills that we evaluate. And so I'm feeling a little uneasy about this language being in there, which is why I'm going to vote no. But I do want to acknowledge to this board and publicly that I do understand that writing skills, superior or good enough, are important. So thank you for letting me say that.
certainly.
Can I just add one more thing to that?
If you can do it in 10 seconds. Ken.
I sure
You're
can.
running out.
There is nobody in this world that is perfect with everything. And I am agreeing with Denise, and I am voting no on that for that simple reason right now. I think that is too conducive.
Okay, thank you. All right, so the motion is to adopt Rule 11C as proposed, starting with Denise.
No.
Brian,
Yes.
Ken,
No.
Tim. Tim, you are muted. We're waiting for your vote. Are you still with us, Tim?
Come in, Tim.
There he is.
I'm having a problem on mute. I vote yes.
Yes, okay. Cheryl,
Yes.
Kimberly,
Yes.
Allison,
Yes.
Barbara,
Yes.
David.
Yes.
I am a yes. Jeanette?
Yes.
Motion passes 9-2. Rule 11C as proposed. Okay. I think we might be out of time. So everything else, I am happy to convene another subcommittee if we want to keep working on this between now and December. The final thing we really need to do is to schedule our December interview dates.
Can I ask something?
Yeah, David.
This is my personal feeling. The fleshing out of what well-qualified means is really important to me. I think it's important to the board. I think I'm a person that I'm active practice, and I've been very disappointed with some of the candidates that have been chosen by the governor that I am appearing in front of. I got to tell you, they're very disappointing. And I think that I would just like to have just a really quick, want to know how controversial this is, because it was something that was brought up by the governor council, who we used the ABA language, which I thought was pretty good. The governor's council doesn't seem to think that we're anywhere, like somehow they trust the ABA, but they don't trust us, I guess that's the way I read it. And I'm just wondering if we could take just a really quick.
So David, do you want to do a straw poll?
Yeah, just so that when the subcommittee meets, we know what we need to work on. I mean, I would like to hear from people that object to this language very briefly so that we can hear your concerns and maybe address them.
I'm not sure Denise has the time for that.
I don't.
Why don't we all weigh in on email? And I'm hearing an appetite for another round of public meeting in December to maybe follow up on some of these threads. So I'm going to try to build that into our December interview schedule. So I would like to set aside, let's see, we're interviewing for 4 open positions in December and potentially doing a public meeting. I would like to set aside 4 days.
I haven't seen a notice of vacancies yet.
It just came in yesterday.
Oh, okay.
So we are good to put out, well, no, I'm sorry. The letter from the governor that starts our process came in yesterday. As soon as we have dates for interviews, I can finalize the notice of vacancy and get that out promptly.
Okay.
So pull out your calendars, please. I have some preliminary dates that I know folks are unavailable. But we're looking at the beginning of December. I'm also just pulling up a calendar here. Okay. Beginning of December, I see potentially December 1st and 2nd might be available. No, we've got nothing on. All right. The following week, December 5th and 6th potentially available.
Yep.
I'm seeing Cheryl says no.
Oh,
Okay. How about December 9th? That's a Friday.
yep.
Is that a possibility?
That doesn't work well for me.
Not for me.
Not
me
for
either.
you. Okay. Moving to the next week. It looks like December. We might have Kimberly for half days on the 12th and 13th. And then we lose Barbara on the 14th and we lose David on the 16th. So we need to find some wiggle room here. How about weekends?
I could do the 12th and 13th.
I could try to move, it's a medical appointment, I could try to move it.
Is that,
I can do that.
do we have other conflicts on the 12th and 13th?
No,
No? Okay. Okay, let's tentatively schedule the 12th and 13th. That is 2 of the 4 days that I'm looking for. So we've got a couple weekends in there. We have, oh, and actually it's possible that we have, gosh, it's far away, but November 29th and 30th. know that's right after your vacation.
That's Thanksgiving, isn't it? Oh, no, 29th, 30th.
29th through the 30th,
I'm okay with those.
November. Any,
Let me look. Hold on. I was just blocking out the 12th and 13th here. Hold on. 29th and 30th.
I will be coming back from a extended time off. And so I'm not sure that my work will see that as an extended vacation, although I will not. So I don't know that I can try,
not ideal, yeah.
but that's really tricky for me.
All right.
I mean, I have a jury draw scheduled for the 30th. Whether it'll go or not is a big question. And then I guess I could tell the court that I have this and they would change it. But if Denise can't make it, I don't know if it makes any difference.
Well, I'm sorry, did December 1st or 2nd not work? I was looking at my calendar.
Carol, who can't do December 1st or 2nd? Kimberly. Okay.
Could you do
Okay.
just the 30th, Denise, versus the 29th?
I could make the 30th. I could have a day. Yeah, I could do the 30th.
I only can do till, well, it depends where we are. I teach a class of 3.
Okay. Let's talk about weekends, everyone's favorite. So if we're meeting on the 12th and 13th, we've got a weekend right before that, the 10th and 11th. Are folks free the weekend of December 10th and 11th?
Will these be overnights?
We can get hotels for staying.
Well, I'm hoping they won't be,
Oh,
in case there's something going on like Saturday night.
oh yeah, you can.
No one's going to force you to stick around, Brian.
We're going to
Plans on
meet at 10 o'clock Saturday night.
We're going to do a bed check at 11 o'clock, Brian.
I have a question, Ella. Are you thinking there'll be 4 days of interviews plus
I am hoping
public meeting?
4 days will cover both interviews and public meeting.
Okay.
As always, I'm realizing we're doing this over Zoom, which is unusual. As always, we don't know how many days of interviews we will need until we get all the applications.
Yeah.
Maybe we want to read.
My estimate is with 4 vacancies, we'll probably need maybe 3 days, my hope. But I want to block off the 4 days, build in for lots of applicants and the public meeting.
Okay.
Yeah.
I mean, I
What's
don't know
the
how you
public
guys
meeting?
feel, but I'd rather go later in the day than have more days.
Agree.
We can work out the details of how late we go once we know the number of applicants, and we can, try to squish it into 3 days or whatever. But I want to block off 4 days because it's as you know, it's much easier to block it off now and not use it than not block it off.
So if we did the 12th and 13th, that could be 2.5 days. If we went later in the day, instead of thinking that we're going to end at 4:30 or something.
Could we just block off 10, 11, 12, 13, knowing that Ella's gonna do some scheduling magic to make it not 4 full days?
I agree.
I cannot do the weekend. That's the only weekend. I can do like the 2nd and 3rd or whatever, the first weekend of December and the 16th, but the 9th and 10th I cannot do.
We may not be able to accommodate everybody's schedule, we have
Right.
tomorrow.
The 3rd is
I mean, I want Allison to be part of it, but.
What is the 3rd?
the Democratic.
We will do it on the day you can attend, David.
Yeah, you guys
You
can
know what?
definitely, definitely.
You can miss that.
Yeah.
So can you do the 11th, Allison?
What day of the week?
Sunday.
Is that?
Sunday.
No, we have like that's,
All right.
that weekend.
What about the weekend of the 3rd and 4th? Are you booked on the 3rd? I'm hearing.
Theoretically, there's a House Dem caucus from 9 to 4.
It's not ideal.
Yes, but I don't know.
Yeah, Tim.
Yeah, what is the public hearing for? What are we doing at it?
We're going to continue this conversation with possibly some revised amendments to the rules that we didn't get to consider today.
Yeah, I was on, as you know, the subcommittee on the rules, and I don't know how many times we met over the summer, fall, went through all these things. And if you were participating in it, it's just hard to see all the issues that can come up. Seems to me the full board has to do it, not a subcommittee, because everyone else is going to have issues with things we come up with. We're not going to be ready. Were you planning to reconvene a subcommittee of some sort between now and then?
That was the thought.
Because I'm not interested, frankly, in serving on it.
Okay. We can have this discussion offline over email. I'm not going to force anyone to be on a subcommittee. If we don't have proposals to consider, we don't need the meeting. It sounded like there was appetite for it. I'd just like to block off these days so that we have something on the calendar, because 2 days is not enough for us to consider four.
Ella, why don't you block off the 29th and 30th if those dates were available initially, and then let me manage my schedule when we get a little bit closer. If that actually worked for everybody but me,
It doesn't work.
Doesn't work for David.
It doesn't. I mean, I can.
That's definitely what we should.
Okay.
I'm okay with that. I mean, if I let the judge know that I got a judicial nominating board thing, they'll probably accommodate me.
If it works for everybody else, let's let David and I try to work our schedules out.
Does the 14th of December not work?
No, we lose Barbara, right? On the 14th, yeah. Okay, so we've got November 29th and 30th with some finagling by David and Denise, and we've got December 12th and 13th. I think that concludes this public meeting. Thank you all. And we will talk soon. I'm going to take us off